नमस्ते। आज हम बात कर रहे हैं देश के 49वें मुख्य न्यायाधीश बनने वाले यानी भावी न्यायाधीश जस्टिस उदय उमेश ललित जी से। देश आजादी की 75वीं सालगिरह यानी अमृत महोत्सव मना रहा आजादी का और 75 दिनों का ही कार्यकाल रहने वाला है जस्टिस ललित का। हम इनसे कुछ जानना चाहते हैं कि पूरे न्यायपालिका को लेकर इनकी क्या योजनाएं हैं, क्या इनके सपने हैं जो हकीकत की जमीन पर उतरने वाले हैं। सिर्फ देश के 75 साल के सपने नहीं, आने वाले 75 दिनों के सपने किस तरह से होंगे, हम इनसे बात करते हैं। सर नमस्ते, आपका स्वागत है सर आज तक में।
नमस्ते। नमस्ते।
पहला सवाल तो ये कि सीजेआई के रूप में आपने पिछले 2 सालों तक, जिनका प्रधानमंत्री ने भी बखान किया कि आपने नालसा के एग्जीक्यूटिव चेयरमैन के रूप में पूरे देश का दौरा किया, जबकि कोविड काल के दौरान भी, उसका कैसा अनुभव रहा और आगे आने वाले आपके कार्यकाल में मुख्य न्यायाधीश के रूप में उसका कैसा अनुभव और कैसा इस्तेमाल रहेगा?
हमने जो देश भर भ्रमण किया था वो एक अवेयरनेस या आउटरीच प्रोग्राम के तहत किया था। आइडिया बेसिक यही थी कि ज्यादा से ज्यादा एरिया कवर हो, ज्यादा से ज्यादा पॉपुलेशन कवर हो, उनकी तरफ ये एक जो लीगल अवेयरनेस की, लीगल एड के अवेयरनेस की जो मशाल है वो एक फ्लेम हर जगह पहुंचे। सो बेसिक आइडिया तो उसका वही था। उसका ट्रांसलेशन हमें उसके अच्छे परिणाम हमें लोक अदालत में जरूर दिखाई देने लगे। जैसे कि कल वाली लोक अदालत जो थी, कल मतलब 13 तारीख को, उसमें हमारा डिस्पोजल 1 करोड़ का मार्क क्रॉस कर गया है। सो मोर देन 1 करोड़ केसेस वी हैव बीन एबल टू डिस्पोज ऑफ। उसमें से जो कोर्ट में पेंडिंग थे वो करीब करीब 30 लाख के मुकदमे हमने, उस 30 लाख मुकदमों का डिस्पोजल हुआ है। 70 लाख वाले केस करीब करीब वो वाले थे कि जो कि प्री लिटिगेशन स्टेज पे पेंडिंग थे। तो इसका एक थोड़ा सा अनुभव हमें ये मिला है कि लोगों की जो नब्ज पहचाननी होती है कि उनको क्या चाहिए। हर जो सिटीजन है उसको अपने जो केस है उसके बारे में जल्दी से जल्दी निपटारा चाहिए और उसको निशुल्क या कम से कम शुल्क में उसको न्याय मिलना चाहिए। उसके लिए वो न्याय पाना एक कसौटी नहीं बननी चाहिए, ना ही प्रोसीजरल रैंगल्स में वो खुद को यानी एंटेंगल देखना नहीं चाहता वो। तो ये सारा जो है, अब ये पहले से ही सबको मालूम है, सिर्फ मैंने वो अनुभव किया है, बस इतना ही है।
Sir, thank you very much for joining with us today, and we're discussing on the day that India celebrates its 75th Independence Day. We're talking to you. You're going to be the 49th Chief Justice of India. The Azadi Ka Amrit Mahotsav is being seen as an opportunity to plan for the next 25 years. So personally, for you, what are the hopes and dreams and expectations you have for the judiciary in the next 25 years?
See, again, as chairperson of NALSA, in the recently concluded our District Legal Services Authorities meet, in fact, the slogan that we came out with is, where do we see NALSA in 2047? So next 25 years. So that's the dream that we have started all our programs in NALSA with that particular vision in mind. So whatever we have started for NALSA, it is essentially covering one strata of the society which is deprived, which is depraved. So therefore, that particular strata of the society needs further or greater look or greater assistance. If you consider that below poverty, there is 70% of our population is below poverty and they are otherwise entitled to legal aid, then whatever we are doing for NALSA with the same vision can also be applicable to the entire judicial framework. So in 1 or 2 sentences, if I have to put it, the process of justice must be fast, quick, expeditious, and as clearly, as precisely as possible. The hallmark of any judicial system is that there must be clarity and there must be consistency. If there are inconsistent views which keep coming up, which keep cropping up, then that is not a healthy idea, because that upsets or that unsettles the entire wheel of judiciary. So therefore one has to be consistent, clear, precise. If the law that gets laid down at the level of the Supreme Court and High Court is clear and precise, then that gives a guiding beacon to the people at the district judiciary level to follow and to sort of, go on that particular path. So therefore that should be the vision for the judiciary.
सर, एक पुरानी कहावत है कि जिंदगी बड़ी होनी चाहिए, लंबी नहीं। लोगों की उम्मीदें आपके कार्यकाल को लेकर ये हैं कि बहुत सारी चुनौतियां हैं, बहुत सारे बड़े बड़े केसेज हैं जो कॉन्स्टिट्यूशन बेंच का इंतजार कर रहे हैं, जैसे मनी बिल है या फिर आर्टिकल 370 है, CAA, NRC है, रिजर्वेशन पॉलिसी है, सेडिशन लॉज हैं जिनको रिव्यू करना है। तो इन चुनौतियों से पार पाने के लिए क्या नई और ऐसी यूनिक योजना आप लाएंगे ताकि ये सारी चीजें आपके कार्यकाल में वो हो जाएं? क्योंकि हर चीफ जस्टिस चाहते हैं कि इतिहास में वो अपने तरह से काम करें ताकि वो काम मायने रखते हैं कार्यकाल से ज्यादा।
आप ही ने अपने सवाल का जवाब दे दिया है वैसे, तो मुझे और क्या बोलना चाहिए। जितना जल्द हो सके, जितनी तीव्रता से हो सके और जितना इफेक्टिवली हो सके, इन सारे जो मुद्दे हैं जो कि पेंडिंग है, उनका हल निकलना चाहिए। वो हल जब निकलेगा तभी अपनी सोसाइटी के लिए एक अच्छा एक गाइडिंग प्रिंसिपल्स होंगे। और सुप्रीम कोर्ट का काम ही वही है कि टू इंटरप्रेट द कॉन्स्टिट्यूशन एंड टू ले डाउन लॉ। अगर वही चीज हम कर लेते हैं जितनी जल्दी हो सके, तो पूरी की पूरी सोसाइटी के लिए एक वो अच्छा लाभदायी एक मिसाल बन जाती।
तो देश उम्मीद करे कि बहुत ज्यादा कॉन्स्टिट्यूशन बेंच होंगी ताकि जल्दी से जल्दी इनको।
हाँ, वो तो हमारा प्रयास रहेगा ही, बिल्कुल रहेगा।
Sir, coming back to your experiences, you're the 6th lawyer in the history of the Supreme Court to be elevated directly to the Supreme Court bench. You're also a legacy in the legal field. Your father, your grandfather were both lawyers. You've also talked about the fact that you're a legacy. How has that legacy and expectation and the direct elevation impacted or affected the way you approach your work as a judge?
It hasn't affected as such. See, whatever the family that you come from, whatever the background that you come from, that is to say that is your capital. How best you improve on your capital or your opening stock is for that individual to decide, correct? There are people who come with the equal stock or equal kind of opening capital, but ultimately it depends upon that individual. So therefore, legacy apart, everything has to come from that at the individual level. I am very, very satisfied that yes, I come from a family of lawyers where there is a background. My grandfather started in 1920. So therefore, to see that somebody from the family is now part of the Supreme Court, that itself is something which is a moment of pride for everyone coming from the family. So therefore, yes, I am definitely satisfied on that count.
Is the legacy something that affects, I mean, does it create more expectations from you as a judge?
It doesn't create any expectations. See, ultimately it is for the individual to come out true when any moment of crisis or any moment of test is actually arrives. So therefore, that legacy definitely helps you, but it doesn't cause any kind of expectations or the feeling that I have to achieve this, or if I don't achieve this, then perhaps I think, I'll be something falling short in my own eyes and estimation. So nothing of the sort. It doesn't affect me at all.
सर, आजकल एक बड़ी बहस हो गई है, राइट टू स्पीच है या बुनियादी अधिकार हैं। दूसरी तरफ कुछ लोग आरोप लगाते हैं सरकार का सेंसर है या फिर सोशल मीडिया पर ट्रोलिंग है। इन तमाम चीजों को ऐसा गडमड हो गया और लोग उस पर अपने अपने हिसाब से बहस कर रहे हैं। आपका स्टेक इसमें क्या है? आपका क्या इसमें मानना है?
See, I always maintain that we are ultimately public servants. Whatever we lay down, whatever we decide, it is for public consumption, it is for public good. So, public has a right to see whether our judgments are something which are coming up to the expectations of the society or not. Ultimately, yes. But at the same time, there has to be a line which must be drawn, and that is, if at all a particular judgment or a viewpoint is on the basis of any research or analysis, if people say that perhaps I think the judge has gone wrong in taking up a particular stand or a particular viewpoint, you may criticize that judgment. So up to that level, so long as it is within bounds, so long as it is within those limits, any such criticism is always a pointer in the direction that perhaps I think the judiciary can also do some course correction. Correct. So therefore, that's a pointer which is a very healthy sign for everybody in a democracy. But that criticism has to be within bounds. It should not cross the limit and become criticism of the person behind that judgment.
सर, पीआईएल के भूमिका को लेकर बहुत सारे सवाल उठे हैं और सरकार की तरफ से ये कहा जाता है कि जुडिशियल एक्टिविज्म है, जिसकी वजह से बहुत सारे फाइनेंशियल स्कीम या इकोनॉमी को लेकर उस पर असर पड़ रहा है, बहुत सारी चीजें वहां अटकी और लटकी पड़ी हैं। तो इसको लेकर आप क्या सोचते हैं, पीआईएल की भूमिका और सरकार का ये कहना बार बार कि जुडिशियल एक्टिविज्म है, तो कितना उचित है या किस दायरे में होना चाहिए? आप
ऐसा है, अगेन PIL by itself is an excellent idea. I'll give you some examples. Say for instance, the decision of the Supreme Court in Madhuri Patil, जिसमें हमने ये कहा था सुप्रीम कोर्ट ने कि जो भी सिटीजन या तो शेड्यूल कास्ट या शेड्यूल ट्राइब से बिलोंग करता है, अगर उसका स्टेटस ही चेक करना है तो उसके लिए एक मशीनरी होनी चाहिए, व्हाट इज कॉल्ड कास्ट स्क्रूटिनी कमेटी। तो किसी भी लेजिस्लेशन में, किसी भी स्टेट में इस तरह का प्रावधान था ही नहीं। तो वो प्रावधान आया कहां से? वो माधुरी पाटिल के जजमेंट में दिए हुए डायरेक्शन से आया। करेक्ट। यू कैन कॉइन दैट टू बी जुडिशियल एक्टिविज्म। आप बोल सकते हो कि ये यानी जुडिशियल एक्टिविज्म है, पर आप देखिए कि वो जो एक दिशा दी थी सुप्रीम कोर्ट के जजमेंट ने, वो आज एवरी स्टेट हैज एक्सेप्टेड इट। हर स्टेट ने एक्सेप्ट किया है। दूसरा आप देखिए कि मेडिकल और इंजीनियरिंग कॉलेज के एडमिशंस में देयर शुड नॉट बी एनी कैपिटेशन फी। तो इस भावना से और इस उद्देश्य से इस्लामिक एकेडमी ऑफ एजुकेशन में सुप्रीम कोर्ट ने आइडिया रखी कि एक फी कमेटी होनी चाहिए, एक रेगुलेटरी कमेटी होनी चाहिए। आज वही सारा जो एपरेटस है सुप्रीम कोर्ट ने दिया हुआ, वो सारा हर एक स्टेट में चलता है। आप मोहिनी जैन लीजिएगा या उन्नी कृष्णन लीजिएगा, जो कि एक राइट टू एजुकेशन वाज सिंपली पार्ट ऑफ डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी, उसको सुप्रीम कोर्ट ने एलिवेट करके कि इट इज अ पार्ट ऑफ योर फंडामेंटल राइट। सुप्रीम कोर्ट के जजमेंट के बाद पार्लियामेंट ने उसको यानी फंडामेंटल राइट का स्टेटस दिया है। इसलिए 3-4 या आप जैसे यानी सेक्सुअल एक्सप्लॉयटेशन ऑफ वीमेन एट वर्क, जो विशाखा जजमेंट हम बोलते हैं, दीज आर पाथ ब्रेकिंग जजमेंट्स। और ये जो पाथ ब्रेकिंग जजमेंट्स है, दे आर नथिंग बट जुडिशियल एक्टिविज्म टू अ सर्टेन एक्सटेंट। करेक्ट। सो आप हमेशा ये सोचते हो कि जो चीजें अच्छी हैं, जो चीजें होनी चाहिए, अगर उसमें कोई एक जगह पर कहीं एब्सेंट है, कोई लेजिस्लेशन या कोई स्टैट्यूटरी रेजिम नहीं है, तो सुप्रीम कोर्ट ने कई बार ही माना है कि भाई then the good societal sort of the dispensation demands that there must be some authoritative pronouncement governing the field। तो उसके तहत कई बार ही होता है ये। तो ये जो टसल है, ये कोई टसल नहीं है, ये हर एक विंग जो है, एक जुडिशियल विंग का एक अपना अपना एक योगदान है कि भाई एक अच्छी सोसाइटी के लिए ये चीजें जरूरी हैं।
Sir, if I may, taking forward from what you just said about there's no tussle, everyone has their own role. In the last few years, we've seen occasions where there has been an outright antagonism between the executive and judiciary. There have been situations where a lot of things have been done cooperatively. Today also we saw the Chief Justice and the Law Minister speaking about the need for cooperation. But when it comes to issues like appointments, when it comes to issues like Collegium, when it comes to issues, several issues have been there when we've seen a lot of sort of so a little bit, public perception is that there is a little bit of antagonism. How have you seen it in your tenure as a judge on the Supreme Court bench, as a senior lawyer, and now that you're going to be the Chief Justice? What is your hope and expectation from what has been going on in the last few years?
If your question is directed at so far as what the Collegium recommendations and how those recommendations are taken by the government, then, our experience has been very, very healthy and encouraging. Barring few exceptions where there is bound to be some, some kind of friction, because the various agencies work in that direction. Every agency has a charter of some, duties and sphere of work which is designed for it. Now, I'll give you an example. Supposing if a recommendation comes from the High Court Collegium for appointment of certain persons as judges of the High Court, naturally, that's one recommendation which comes, which is the originating idea. That originating idea will then be supplemented by the government's recommendation. It will again be supplemented by what is called the consultee judge's opinion. So therefore, that's again one factor or one facet of the matter. And finally, the assessment will be made by the Collegium in the Supreme Court, correct? अब ये जो जितनी agencies है, every agency has a work, has a particular job to perform. Governmental agencies may actually be looking into what is the profile of that individual. The profile of the individual, perhaps the Collegium may not be aware of, correct? The Collegium may be aware of his professional performance in court. But whatever happens behind that, the personal or the individual level, perhaps the IB reports may not be sort of, so good. So therefore, the governmental input on that front is something which will be seen by the Collegium. And it is final analysis is done by the Collegium and the names are then finally recommended. So in this entire process, there are bound to be some kind of, every agency wants to perform whatever is the job assigned to it to the best of its ability. So therefore, there is bound to be some kind of viewpoint which may get expressed. And so these are not tussles as such. These are only what is called the checks and balances in the system.
Outside of the appointments issue, there have been a lot of instances.
I haven't seen any kind of tussle. If you can name something, then I can respond to that.
सर, आज भी जब सुप्रीम कोर्ट परिसर में समारोह था आज़ादी का अमृत महोत्सव, उसमें भी ये हुआ कि कॉलेजियम सिस्टम को लेकर आपको लगता है कि उसमें कुछ सुधार की जरूरत है, या फिर एनजेएसी जिसे सुप्रीम कोर्ट ने रिजेक्ट कर दिया, क्या वो किसी दूसरे रूप में उसकी जरूरत है, या कॉलेजियम सिस्टम में भी कॉलेजियम को अपने इंट्रोस्पेक्शन करने की जरूरत है? इसमें आपका टेक क्या है?
See, whatever has been laid down by the bench of 5 judges of the Supreme Court, they have interpreted the provisions of the Constitution, they have interpreted whatever was the amendment to the Constitution. And the decision laid down by the court is that the Collegium system is here to stay, correct? Then if it is to stay, then we must work in that direction. So therefore, for us, we will be simply working in that direction to see that the maximum output and qualitatively good results are actually sort of brought about. So that should be the function of, every succeeding sort of, members of the Collegium.
तो कुछ इसमें आपको लगता है कि कुछ और पारदर्शिता आपके नेतृत्व में सुप्रीम कोर्ट कॉलेजियम काम करेगा तो उसमें आएगी?
पारदर्शिता तो होती ही है। पारदर्शिता आप ये नहीं समझ सकते कि ट्रांसपेरेंसी इतनी इस लेवल तक या इस हद तक हो कि हर रिकमेंडेशन के पीछे जो डिस्कशन होता है वो भी पब्लिक डोमेन में आए, वो नहीं आ सकता, करेक्ट? पब्लिक डोमेन में वही चीजें आ सकती हैं जिसका कि कुछ हद तक के सीक्रेसी भी मेंटेन होनी चाहिए, करेक्ट? और हर चीज को आप खुले इसमें नहीं रख सकते हो, तो एक ट्रांसपेरेंसी की भी अपनी एक लिमिट्स होती हैं।
Sir, speaking of transparency, and as our last question, I'm taking this to the new big things in the judicial system. We're talking about e-courts, we're talking about live streaming of court proceedings, we're talking about digitization, e-libraries, etc. court has been talking about live streaming as the next big thing for transparency, as we've just been discussing. What is the reason for the delay in actually implementing the system? Are there any reservations, concerns, or is it just because getting any new technology simply takes time?
See, there are no hurdles as such. Now, let us test it. You know, when we were in the pre-COVID days where it used to be completely physical form, and whoever wanted to listen to the proceedings in court would be required to attend in person and be present in court. There was no such thing that any deliberation or discussion was classified or was not to be heard by any section of the society. As a temple of justice, everything was completely open and transparent before anybody who wanted to remain present. Except for certain matrimonial matters, custody issues where in-camera proceedings are actually ordered by the court. Except for such minuscule percentage of cases, otherwise every single proceeding in court was always open to to be watched by any member of public. If you accept that as the basic idea, then live streaming is nothing but what? Extension of the same principle. Correct. Today, we may not have actually gone whole hog on the live streaming issue. There are certain high courts which have started that. Gujarat High Court was one of them. But at the same time, when you adopt this virtual platform, to a certain extent, you are actually opening the doors beyond your, the normal courtroom. So anybody and everybody, whether it be it in Chennai or Ernakulam, can be party or privy to the proceedings in court. So therefore, that's where we stand. So it's not as if that there is any mental block against live streaming. It may be that our technological sort of perhaps I think the leaps may require some time.
So are we likely to see live streaming of Supreme Court during your tenure?
I can't guarantee that. That's the job which is being looked after by an esteemed colleague of mine, Dr. Justice Chandrachud. So therefore, we will certainly sort of see anything on that front.
Just one little addendum to this question. What are the big things that we've been talking about e-courts, we've been talking about expansion of the judicial infrastructure. So what are the things that you would be focusing on during your tenure?
See, that's an ongoing process. E-courts is not something which has started recently. It has been going on. That's a very ambitious and very extensive program to link every single court in the country through the what is called the virtual platform. It has various manifestations. That is, the entire record can be pulled, here in this court, and entire record can be available. So therefore, there are multiple kind of usages and the user principles there. So it's not something which can be put in top gear at any juncture. It is going at a speed which is decided and which is predetermined. So therefore, I have nothing else to do on that front. It is being looked after by a very competent person. So therefore, he'll take care of that.
All right, sir. So this was Justice Uday Lalit, who will take oath on the 27th of August as the 49th Chief Justice of India. Thank you very much, sir, for speaking to us. On the day of India's independence, we were talking to the next Chief Justice of the country on various issues and what the judiciary will be looking forward to. Thank you very much.
Thank you.